Please be seated. We'll hear argument in case number 240205, Huffman Asset Management versus Colter.
May it please the court, Mr. Henderson will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
May it please the court. Good morning, almost this afternoon, Your Honor. The issues in this case involve the interpretation and application of sections 5.251 to 2.53 of the Texas Organizations Code relating to substitute service on the Secretary of State. As I will discuss, there is a disconnect between the three branches of government. The legislative branch, who enacted these codes, provisions back in 2003. The Secretary of State, who appears to be in lockstep with the legislature and the plain text of the statute. And finally, the judiciary, at least the Court of Appeals below, have issued a mixed bag of opinions. This court has not addressed this issue specifically. In some instances, such as the Dallas Court of Appeals, courts have used the terms registered office and the most recent address on file with the Secretary of State interchangeably. Alternatively, there's been some cases in some courts that come up with their own hybrid addresses for purposes of the statute. The statutes that we're talking about, or the code provisions rather, had its genesis with respect to limited liability companies, which are the two defendants in this case, come from the Texas Limited Liability Company Act, which is Article 2.08A. And that originally said, whenever a limited liability company or foreign limited liability company shall fail to appoint or maintain a registered agent in the state, or whenever its registered agent cannot with reasonable diligence be found at the registered office, then the Secretary of State shall become the agent for process. But important, in that former statute that's now been superseded by the code provisions, in the event any such process is served on the Secretary of State, the Secretary of State shall forward the process to the limited liability company's registered office. When the Business Organizations Code was enacted in 2003 to become effective in 2006, that section, at least with respect to limited liability companies, of course the code made it applicable to all the different kind of entities, whether it's corporations or limited liability companies or other filing entities. They changed the forwarding address from registered agent or registered office to the most recent address of the entity on file with the Secretary of State.
What are the ways that that address can be put on file with the Secretary of State?
The address is put on file, at least my understanding and through practice, is through, first of all, the statute, the Business Organizations Code just got recently amended, where now the Articles of Organization have to put a principal office address in your certificate of formation. That just happened in the last year or two. As far as the prior entities, or the entities before that, each entity has to file a public information report with the State Comptroller's Office. And that has mailing address, principal office address.
I saw that in the brief as the one that would have solved this problem. But are there other ways? Like what if an entity just sends a letter to the Secretary of State about some topic, requesting some information or whatever, and on the letter there's an address, and that letter gets filed? Well, is that now the most recent address?
That I cannot answer, Your Honor, because I'm not I'm conversant in the SOS Direct website where you can see what's been filed with Secretary of State, whether it's public information reports, a change of registered office, the certificate of formation, amendment to the certificate of formation.
But any one of those things, at least, I guess you would just click on the most recent one and see if there's an address, and if there is, that's the address that, I take it, you think the statute requires.
Well, to answer, first of all, to answer your question about can you send a letter into the Secretary of State, will they file that and put it on the SOS Direct? I don't know.
Does it have to be put on SOS Direct to satisfy the statute?
I don't know. It's similar like the e-file Texas where you can file a letter to the judge or the court and have that on the record. I'm not familiar whether you can do that or not, but to answer your next question is to how they use, the Secretary of State gets the information from the comptroller on the public information report. The Secretary of State puts it on their website. And so if, for instance, if I wanted to sue a football team in Dallas, I'm a season ticket holder, and I don't like the trade they made earlier in the year, I would look, first of all, I'd look at the controller's website, taxable entity search, where they would show an address, and it would show the Dallas Cowboys address on, Champions Way or whatever it is up in Frisco at the Star. Underneath that, it also has a registered agent address on the taxable entity search. On the SOS Direct, if you go through the screenshots, there is an address at the top that will show that Cowboy address where the mailing address or the principal office address is. Then it'll have registered agent address different on that. So that's how you find it, but that's, I assume, how that information gets from the public information report into the Secretary of State's office.
But if there's a more recent filing than that, does the statute require using the address on that more recent filing
Yes.
than the PIR?
Yes.
And so the question is, what constitutes being on file?
Well, I think
Not just the PIR. That'd be very convenient.
well,
If
the
it said-
PR does appear on the Secretary of State
Sure, but
website.
we're talking about the most, it doesn't say, address to the most recent PIR
No.
address. It says the most recent address of the entity on file, so
And
decide what that means, because we can't just assume, I think, that it's always gonna be that, can we? Or can we?
I think chronologically, when you're filing a lawsuit or you've attempted service at the registered agent's office and you can't find them, or bad address, or in some instances under the statute, if they don't maintain a registered office, you would call the Secretary of State and say, or look it up yourself and determine at the bottom of the stack what addresses are there.
Could we offer some clarity by at least saying, if it's something that you're required to file with the Secretary of State that has your address on it, then that's going to be a more recent address on file? Maybe not if you just send in a letter, asking some question and it happens to have a new address on it. But do we have to decide that here?
Well, I don't know, I don't believe you do.
Because the address that you contend should have been used was in a report that was required to be filed
Yes.
with the Secretary of State?
Yes.
Okay.
Yeah, and specifically on the Secretary of State website, when you see on the the FAQ section of their website, which I have in the principal brief, or brief on the merits, as an exhibit in the appendix, it says, how can you change the address of an entity? And it says, well, you can't do it. You can change the registered office or registered agent through Secretary of State. You have to do that through its, what I call CRO, change of registered office form, e-file. But as far as the entity address, you have to go through the state controller's office. And you have to file it with them, who in turn, under the tax code, shoots it back to the Secretary of State, repopulates the field on SOS Direct, and you have what essentially is the mailing address or the address that is used that we contend under the statute.
Setting aside the websites, do we know how it plays into being the most recent address on file with SOS? This 1 Texas Administrative Code 71.21, SOS is one of their rules. The name and appropriate address of the person being named as defendant must be provided by the person who's seeking service. Does complying with that SOS rule make the address that's provided the most recent address on file with SOS?
Are you talking about the promulgated, I'm sorry, Your Honor. Are you talking about Form 2401?
No, I'm talking about 1 TAC, Section 71.21 sub A.
I'm not so sure that gives us much clarity, other than it's a required address by the tax code that's to be put into the public information report. The interpretation that the petitioners forward or promote is that it should be at the most recent address of the entity on file with the Secretary of State. And the intent of the legislature when they enacted the code was they know what registered office was under the former statute on the Business Corporation Act, and they used it in both places under the Limited Liability Act. They used it in the same provision for if you can't find that registered agent at that address, then forward it to the registered agent at that address. So when they enacted the code, they addressed many of the provisions or many other related provisions that was in the TBCA, the the Limited Liability Act, and that chart was in our reply brief that's in the appendix. And it shows all the different statutes that had, for instance, the long arm statute that was discussed in Wachovia versus Gilliam, which is sort of the bell cow case about whether or not the Whitney certificate or the certificate of the Secretary of State, or whether it shows in the record about where did the address go, where was it forwarded to. And that was under, for a foreign filing entity, under the TBCA 8. I believe it's 8.011B. But in that instance, but in this instance, they made these changes from principal office or last known address of so-and-so. And they all made it conform under 5.253. And now we're left, this court is left with the issue about what is that address? What's the most recent address on file? As I said in the brief, the TBCA differentiates between registered office and entity address in many places. The case I want to point out to the court, and I think it sort of sums up, it's sort of a combination of some of the arguments I made. It's Air Voice Wireless LLC versus M&E Endeavors LLC, 2016 Tex App Lexus 10393 from the 14th District, September 22nd, 2016. In construing the long arm statute, 17045. That was a statute in Wachovia. And Wachovia versus Gilliam, in the footnote, says these are all the statutes that it allows for substitute service on Secretary of State or other government officials. It says, if the legislature had intended the address of a non-resident's registered agent and the address of a non-resident's home office to be interchangeable, it could have stated so in the long-arm statute. That was at pages 10 through 11.
Any further questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Nunnally will present argument for the respondents.
Mr. Chief Justice, may it please the court. Public information reports are required by 17203 of the tax code. And the tax code has two sets of requirements. One is in A4, a requirement that the principal place of business be filed. The other is in A5. I may have the A4s and 5 transposed. In A4 and 5, one subsection says that the public information report must set forth the principal place of business of the entity. The other says that it must set forth the registered agent who is required to be filed by 171.354. The petitioner's position has the problem that what if a public information report were filed with two addresses? One address is a principal place of business at 114th Street. One address is a registered agent's address at 100 Commerce. In that case, there would be two most current addresses on file in the same public information report.
Why don't you just send them to both?
Because the statute doesn't say that. The statute says send it to the most current address.
Well, but
singular.
this is a due process issue where the whole idea is that you give notice to the other side about what's going on,
I
right?
understand the court's your point, Your Honor, but the statute actually says to the most current address. But the public information report every year must be updated with the correct principal place of business and with the correct registered agent name and address. When it is filed with a blank for the registered agent, that merely indicates that the prior year's filing or the filing of record, the registered agent filing, still is in effect. So every time that a public information report is filed with the registered agent blank, it in fact is showing the registered agent's most current address is still the same. So it would make more sense, I submit, Your Honors, that in interpreting the statute, the most current address should be the most current address of the registered office, because that's the address that has to be provided every year. I don't believe it would be an excuse to say, we have under 17203 not filled that in. We didn't fill in that information, so somehow we should get the benefit of a different registered agent address, a different service. Instead, we look at, did Texas Business Organizations Code really intend to change the general rule when it was codified? 1.001 of the Business Organization Code says it's mostly about modernization and about plain language.
But we have a lot of cases saying, even so, when it's just a recodification, if there's a substantive change in the wording, that controls.
I agree, Your Honor, that there is case law that says that, and at the same time, that's some evidence towards whether there was an intention to make a change. And the question here is, there certainly is no statement of the most current address being the principal place of business. There's no clear indication that the principal place of business will somehow become a new most current address, because every time the public information report is filed, the registered agent address is also affirmed to be current, also affirmed to be correct.
Does it matter that your client had actual notice of a lease provision that said notices shall be sent to a particular address
In part, that doesn't matter because it was not raised in the court below, Your Honor. It was not raised in the Court of Appeal. That argument that there might have been some other place to send notice was not the argument. In fact, the argument.
But does that notice then correspond with the principal place of business most recently on file at the Secretary of State's office?
I don't have the lease open in front of me, Your Honor, but I don't believe it does. I would have to double check the
Different.
lease, Your Honor. And I apologize, I just don't remember the content of that section of the lease. But there's no question that the petitioners didn't keep their registered information current, the registered agent information current. In the motion for new trial, the petitioners filed a statement that the addresses were bogus. Now, these are addresses that they had supplied and failed to update. These were addresses that they were sending public information reports on every year, and that the motion for new trial was they were bogus and that we knew or should have known better. But it doesn't make sense under 17203 to file a public information report leaving the registered agent blank, so it will be the same registered agent as the most current address, and then argue that it's bogus to rely upon the registered agent that's set forth in the notice. It's not as though there is some different time sequence in which a registered agent is filed and then 6 months later a principal place of business is filed. Instead, the public information report is filed at the same time, and it has both spaces. It has the space for the principal place of business, it has the space for the registered agent.
But in this case, you said the registered agent was blank.
It was blank, which.
So why doesn't that mean that the principal place of business is then the most recent address on
Because
file?
the affirmation is required by 17203 that the registered agent be provided. When it's left blank under the public information report, that merely means the one on file is still current.
But we had a similar situation in Wade versus Valdatero where we said unless a failure to update an address was intentional rather than a mistake, due process requires a lesser sanction than trial without notice or an opportunity to be heard. And so why shouldn't we interpret most recent address on file with those due process considerations in mind?
Well, because then the question still raises, is most recent address on file really refer to principal place of business, or does it refer to the registered office of the corporate, of the LLC?
Could be either, right?
It could be the registered office of the LLC.
Whichever one is most recent.
Because it's the registered office of the LLC. I understand the court's point, but it's the registered office of the LLC, Your Honor, that is the place that service can be made. The registered agent is required to run it as an office, not do a mailbox, be available for service during usual time and days. It makes much more logical sense, Your Honor, I would argue, that the most current address is the most current address of the office that's supposed to receive service of process. That the most current address in the statute is the 5201 through, puts in the requirement of the Business Organizations Code, puts in the requirement that a registered agent be maintained, and that there be a real address, not a mailbox location. It provides in 5202 of the Business Organizations Code, here's how you change your registered agent. Because the registered agent is so important a function that you're supposed to file an additional form to change your registered agent. That didn't happen here. And the question is, the case law, we said a number of cases in our brief, is there a reward for failing to fill out a form accurately when the form requires you to attest to a state agency what the answer is? And I submit, Your Honors, that filling out a form inaccurately, being asked to supply the registered agent and failing to supply the registered agent in a form signed is a bit of a different situation. That's a situation in which 17203 said, under the statute, you shall provide that information.
Could I ask you a question, Counselor, about this representation on page 34 of your merits brief? You say that section 5.201B3 provides in pertinent part that the filing entity must maintain a business office at the same address as the entity's registered office. But when I look at the statute, if I read just B and 3, the registered agent must maintain a business office at the same address as the entity's registered office. So basically it's saying that isn't it saying that the registered agent has to be at the registered agent's address, not that the entity has to be at the registered agent's address?
Well, it says, I believe, Your Honor, that the must maintain a business office at the same address as the entity's registered office.
No, but if you start with B, the registered agent, skip to 3,
Yes.
must maintain a business office at the same address as the entity's registered office.
Agreed. The registered agent must maintain an office, and the entity, by implication, must also maintain a registered office.
Well, but why would B impose such an obligation on an entity when it only says the registered agent must?
Because it says in the B3 in the second phrase, as the entity's registered office. So there must be an entity's registered office, or else the registered agent can't maintain the address at the same address.
I mean, isn't registered there referring to the registered agent has to be at the registered office, but you're saying the entity has to be at the address as the registered office.
By definition, an agent who is at an office which is an office of the entity is maintaining an office at which the registered agent is present. And I do believe that B, the registered agent must maintain a business office at the same address as the entity's registered office, means that the agent is maintaining an office, but the entity is also maintaining an office, because the little subordinate thing at the end is the entity's registered office. If the entity weren't maintaining an office, then it would be hollow words.
But does that suggest that if you want to have a registered agent in Texas, then you also have to be a registered agent's landlord?
No, it means merely that the registered office could be an office that the registered agent maintains for one. The registered agent could handle that service. I think a number of registered agents do handle that service, but that office is deemed an office of the entity.
Right, it's the registered address.
It's the registered address, yes, Your Honor.
But isn't there a distinction in the Business Organizations Code between what the registered address is and some of these other addresses that we're talking about?
The Public Information Report section of the tax code has a subsection for the principal place of business, and it has a subsection for the registered agent. So there's got to be disclosure of name and address of the principal place of business and name and address of the registered agent. And that disclosure of name and address of the registered agent, required to be in the Public Information Report, also is required to be at the same address as the entity's registered office. And so I think I agree with part of what Your Honor's point, which is it could be it's the registered agent is maintaining a registered office for the purpose of service of citation or other process. But that's precisely the point here, that the best interpretation of this statutory change is to continue to serve the registered office, because that's the office that is receiving process. And if someone yearly fills out a form that's inaccurate, that's not some casual negligence, that's an official form filled out to the Secretary of State, to the comptroller, to the tax folks, who are going to then forward it on to the Secretary of State. And as a result, what happened with my clients here, which was that they got a certificate of fact and put it into evidence from the Secretary of State of what is the address for the registered agent and what's the name of the registered agent. There was no showing in the trial court that there was a most current address argument. So there was no argument in the trial court that the most current address for purposes of the statute was the principal place of business. Instead, there was the argument that there was a Craddock basis for why the mistake happened. In the trial court, if one wishes to show that the principal place of business is, that the most current address is different than the one set forth in the certificate of fact, filed in connection with the motion for default judgment, then it's incumbent upon the movement to actually provide that evidence in the trial court to that effect.
I thought there was also an argument in the motion for a new trial that the notice of default judgment was the first time they received any notice of anything in the lawsuit.
There was that thing, and the certificate of last known address, this court has issued a case that says it applies a different standard on where the last known address goes to than does the normal registered agent statutes.
But when a trial court has a motion for a new trial, and at that point realizes that the certificate of last known address went to one address, and the address for service of process was a different address, doesn't that in and of itself lead to the conclusion that there may have been a notice problem, in which case we should start over with a new trial?
Your Honor, I respectfully disagree, and the reason why is that it happens all the time and throughout the case law in which the plaintiff knew that the principal office was somewhere else. The plaintiff knew that that was a bad address, and yet the cases have throughout said the plaintiff may rely upon the registered agent information, may rely upon the registered agent.
Right, and I think their argument is the change to the statute was to abrogate some of those technical defaults where the plaintiff knew when they served the Secretary of State asked the Secretary of State to forward, they knew the address was bad. And I'm not saying that's the case here, but when you provide a different address for service of the judgment as opposed to service of the petition, is that problematic? Just generally, and maybe nobody complains about it, and so the default's upheld and it goes into collections or whatever, but if somebody comes in on a motion for new trial and says, hey, this is the address that we got and we received notice of the judgment, we didn't get notice of the other.
And here, of course, the process server tried to serve at all these addresses.
Right.
But I don't believe the statute can be stretched that far, that the amendment is not that great. As my friend on the other side has pointed out, the legislature knows that if the legislature wanted to say, send it to the principal place of business, the legislature could easily have done that.
And what you're saying is last known address means last known address of the registered agent. And that you did serve the last known address of the registered agent.
Most current address
That's on
means
file.
most current address of the registered agent.
That's on file.
And we did serve that. And the only evidence in the record at the motion for new trial for what that address was the certificate of fact issued by the Secretary of State. So had my client served at the other address and a default had entered, we certainly would have had an argument in the courts below and maybe someday in this court that statutory change means the opposite, that the statutory change means it's the most current address of the registered agent. So from a plaintiff's standpoint, as important as due process is, it's also important to due process that plaintiffs be able to know from the statutory scheme who to serve.
But I still am not understanding how you're getting around Wade, where we said that unless a failure to update an address was intentional rather than mistake, due process requires some lesser sanction than trial without notice or an opportunity to be heard.
There's no showing that it was unintentional to fail to update the thing. That's in the Craddock showing in the trial court. There was no evidence that this was a negligence, this was a mistake, this was an omission. From our evidence, though, there is a document filed every year, and the last year being, I guess, the one important to this, a public information report that requires the person to fill out the right information.
I think that we also noted that some excuse will generally suffice to show that the defendant's failure to answer was not conscious disregard.
But that that Craddock, though, point has not been brought to this court. The Craddock point was brought up in the trial court, but Craddock is not in the points of error before this court. So that issue, the Craddock issue, is not before this court.
Well, just in general, getting out of the weeds of the service problem, if the Court of Appeals at the end of the day decides there was not sufficient evidence to sustain, to affirm the mental anguish piece of the damages, and so it's going to remand for a new trial anyway, at that point, doesn't it make sense to just have a whole do-over now that both sides are present? I mean, it seems to me you shouldn't get an advantage and just get to retry the damages piece and have no ability to contest liability for having taken a default judgment, whereas you wouldn't get that relief if the case had been litigated to judgment with two sides present.
Defaults are sometimes harsh, Your Honor, but they're part of our system for a reason.
Yes, but does that make sense?
In this instance, yes, Your Honor. And I see I'm out of time, Your Honor. If there are any other questions?
Any further questions? Mr. Nunley?
Thank you, Your Honor.
Mr. Henderson, you have 5 minutes.
If the registered agent address was correct and would have properly given notice to your client, but the later filed principal place of office, the principal place of business address was incorrect, and the plaintiffs chose to serve the principal place at being the latest one on file, would you be here arguing that they should have served the registered agent at the correct registered agent address?
I'm not sure how to answer that, Your Honor. That's,
I mean, just reverse the situation, and the bad address was the more recent one.
if the
And the
bad.
good address was the older one, because that was the address that the company had designated for service, as its agent for service of process.
Well, if we had put a bad address for the most recent address on file with the Secretary of State, and
Or
that.
just for some reason it didn't get to you. Even if, say it was correct, but it just didn't get forwarded properly. But if they had served the registered agent, it would have.
If they would have served the registered agent at the correct address, then like when we got the last known address of the default judgment, in my case, or our case, we would have answered. But I'm not following the hypothetical, Your Honor.
Well, I'm wondering if this makes it very difficult to divine what the correct address is for service of process, sort of to Justice Young's questions about what address is the address on file.
I will respond to your colloquy with opposing counsel about the registered agent address. The most recent registered agent address or office address, to me, that is redundant, because there is, at least in my experience, in my statute, there's one registered agent address. And does that mean the legislature, when they enacted the deal, said we're going to have the most recent address of the entity as opposed to the most recent address of the registered office, where you're interjecting words? But the most recent of a registered office address seems redundant to me. It doesn't make sense in the interpretation of the statute. As far as the registered agent address on the PIR, which was left blank, as the Secretary of State said in their FAQ section, the only way to change that is through a change of registered office. So whether I put, Colorado Street and 14th Street is my address, and that's a wrong address or whatever, it doesn't get through. It's really the Secretary of State through the CRO, a change of registered office that's filed with the Secretary of State. When I was talking about my judicial branch, executive branch, and the conflict, I point out in tab A, in the defined terms of, tab A of my reply brief, that, that has the Secretary of State, business organizations define terms, and it has the entity address defined in that. I know it's not the statute, but it's the executive branch in their view of the world. And it says, for a Texas corporation, this is the address in the public information report. For a foreign entity, this is the address listed in its application, certificate of authority, or other similar document in its principal office. For a professional association, this is the address of the principal office. For a limited partnership, this is the address listed in the principal office where the records are kept. So I submit, this, at least Secretary of State is saying, look at the public information report. I know you're having to cobble all this together and come up with an address, but what I can confidently say is the statute does not, no longer says it's a registered office address. It's the most recent address on file with Secretary of State.
If we were to read that to mean, as your opposing counsel suggests, most recent registered office address of the entity on file with the Secretary of State, who would you serve if they had never appointed a registered agent?
If they never appointed a registered agent, or doesn't have a registered office, or didn't file anything with Secretary of State, which goes into 5.2.
Well, no, say they filed stuff with the Secretary of State and it has a principal place of, principal office on there, but they're right that the statute means only the most recent registered office, and they never appointed an agent. I think the outcome under the rule they're advocating would be you have no place to serve somebody.
Well,
by substituted service from the Secretary of State.
and yeah, I don't disagree with that. I mean, I know there would be the hypothetical of I'm sorry, my time's up. But under a hypothetical, if there was no registered office, no agent under 2.51, and there's nothing in the Secretary of State's file, then I think, well, especially for foreign entities, I think you have to go through a long-arm statute, but I digress. Thank you, Your Honor.
Any further questions? Thank you, Mr. Henderson. Thank you to all counsel. That concludes the argument set for today, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.